once this box is ticked, so when a display is part of a commercial offering, it's likely to be used in the course of trade, then we have a number of potential trademark disputes. If not, they don't do that, they may lose the mark in the end of the day.
You're listening to IoT and IP Explained with Claudia Tapia, where experts discuss the latest in technology and intellectual property.
Imagine you're driving in an unfamiliar city. You tap the navigation screen in your car, and within seconds, it shows you the fastest route, nearby restaurants, gas stations, charging points, hotels, even the logos or some brands. The system may make suggestions before you ask, based on the time of the day, your past behavior, or real-time traffic and service availability. The functionality is powered by a mix of technologies. At the core, we have GPS, determining your exact location and mapping software. And this often comes from providers like Google Maps, which supply data about nearby services. And on top of that, there is a database of points of interest, which includes business names, locations, opening hours, and often brand logos. The data can come from the map provider itself, from third-party aggregators, or directly from the brands through partnerships or licensing agreements. The car system providing information integrates this data and sometimes combining it with your calendar, driving patterns, or even the weather forecast to suggest relevant stops. But behind these scenes, each one of those logos and brands mentioned involves legal, commercial, and sometimes competitive considerations. Today, Noam Shemtov and I will explore the trademark issues behind this feature. Our goal is to help you understand not just the legal theory, but also the practical realities facing both automakers and brand owners in this space. Noam is Professor of Intellectual Property and Technology Law at Queen Mary University of London, but he's also the Director of Queen Mary Property Research Institute. Noam, I'm delighted you said yes to being part of the podcast.
Thank you, Claudia. It's a real pleasure. I'm looking forward.
Let's start with a first basic question. How common is this feature, having these vehicles guiding drivers to nearby services in today's automotive market?
So my understanding is that most mid-range to premium vehicles, especially those that were released into the market in the last few years, are equipped with such infotainment, I believe. So information and entertainment combined in one. So infotainment systems that feature real-time navigations. We have premium car producers, the usual suspects coming from Germany, the UK, the US now, Tesla and so on. On the one hand, we also have more mass market brands that offer that in the upper trim levels and through certain optional tech packages, so Toyota, Volkswagen and their like. And in addition, we actually have the what we can refer to as aftermarket platforms, such as Android Auto, Apple CarPlay, that are accessible across most of the brand range. They deliver POIs, third-party apps, so Google Maps, Waze, and their like.
So it's really a lot of things going on right now.
Mm-hmm.
When a car displays a service provider's logo, what trademark issues can arise?
So, first of all, we for example, especially in the EU and the European context, displaying a logo in the vehicle interface may constitute, we know that we need to have use in the course of trade. So first of all, it's the question of use in the course of trade. And once this box is ticked. So when a display is part of a commercial offering, it is likely to be used in the course of trade. Then we have a number of potential trademark disputes. First, the question of likelihood of confusion. If the display of the logo is considered to be under the relevant circumstances, some kind of endorsement or affiliation of sponsorship, then the consumer may be misled into believing or seeing a connection between or commercial relationship between the vehicle manufacturer or the information system provider on the one hand and the brand that is being displayed on the other. So we may have a confusion, likelihood of confusion questions arising in this context. And then we also have the questions of dilution and tarnishment. So we know that generally speaking, using a logo without permission may expose the trademark to certain unfavorable contexts. So for example, low quality services, inaccurate directions, which is one of the main issues. So that may be an issue for the tarnishment. And then, of course, we have dilution by blurring. And this is where the distinctiveness of the famous mark is weakened due to the ongoing use of trademark in question.
Yeah. So quite some things that we need to take into account.
Unpack.
Yes. The overuse of a well-known mark in the interface could, as you mentioned, risk dilution or loss of distinctiveness. Why is this relevant for trademarks?
So generally speaking, when we are referring to dilution by blurring, we are referring to, as you said, the loss of distinctive character of a well-known trademark. I believe a long time ago, a certain scholar referred to it as death by 1,000 pinpricks. So it's a very slow erosion of the distinctive character of the mark. Now, in the context of car infotainment systems, for example, if a famous logo is shown routinely or indiscriminately or amongst less known marks, the argument is that it may lose its power to uniquely signify a specific commercial source. When, for example, the more a certain mark is used in kind of a general, non-curated, algorithmic type of display, arbitrary display, the more likely it is that perhaps it would be conceived by the consumer as generic or merely descriptive, say, of a category of goods. So this is clear risk. And the other branch of dilution, so dilution by tarnishment, is so we're referring to dilution by tarnishment is when we're referring to harm to the reputation, so damage to the reputation or distinctive character of the mark through an association, for example, with unsavory or inferior contexts. So, for example, if you have a navigation system that directs users to branded locations that, for whatever reason, fail to meet the expectations of the user, right? So, for example, when you have data errors, wrong directions that cause inconvenience, this may be associated. Then what you may have here is an association in the mind of the consumer between the brand and a negative experience. And this is where tarnishment may kick in.
At the same time, in many cases, there's no trademark infringement or dilution risk within this context of this car feature. Could you explain why is that?
Yeah, we may have an issue where, for example, in the context of blurring, when we have, or maybe may have, a display, an indiscriminate display of a trademark, but on the contrary, or on the other hand, if we have clear and precise play of trademark in relation or in a referential or descriptive manner. So, for example, I'm using my information or infotainment system uses the mark Texaco in order to direct a driver to a Texaco gasoline station or petrol station, then we shouldn't have any problem here. There is no dilution in such an example. So it's really not every use in an infotainment system, but it depends on the type of use. When the use is factually and contextually accurate and not misleading, then we shouldn't have any problems.
Then In fact, there are many companies that are paying to be included. We will talk about this right away. But before that, is permission always required to display a brand in a car navigation system?
I think we're going to perhaps speak about that in a bit, but there are certain jurisdictions, for example, in the United States, when we have the nominative fair use doctrine. The nominative fair use doctrine permits the use of a trademark to identify a brand under certain circumstances. So I gave the example of Texaco, right? So you use Texaco in order to direct drivers to a Texaco petrol station. No problem there. And when there is no likely infringement, we don't need any permission or any license. Permission is required only in circumstances where without the permission, infringement is likely to take place. So when it's not, we don't have likelihood of infringement, we don't need to have permission.
You mentioned US.
Mm-hmm.
What about Europe? And what about within Europe?
In the context of exceptions to trademark law, we do also have a European arrangement or a European framework to actually address such situations. It is, I think it's fair to say, without getting too much into detail, it is somewhat narrower, right, than nominative fair use. But perhaps I can explain that by, or refer to that by first talking in more detail, if that makes sense, about nominative fair use, and then from that,
Sure, please go ahead.
Nominative fair use is a doctrine that was developed under U.S. trademark law. A couple of cases, actually a Toyota case, a New Kid on the Block case, but essentially it is about the possibility of to use another's trademark without another's permission under limited circumstances. And those circumstances essentially are where the product or the service in question cannot be readily identified without the use of the trademark. Defendant does only to the extent that it's reasonably necessary to use the mark. So only so much of the mark is reasonably necessary is used. And very importantly, the use does not suggest sponsorship, endorsement, or affiliation. Now, if we think about Europe does not have or courts developed type of doctrine, but we do have Article 14 of the European Trademark Directive that allow us to use a trademark in order to indicate its intended purpose, so that the intended purpose of a product or a service. But, and this is the addition that perhaps under circumstances may render the scope in Europe somewhat narrower, as long as it is done in accordance with honest practices in industrial and commercial matters. This is what the exception or the exclusion provides. So, for example, if the use is commercial in nature, you may have a problem to show that it is used in accordance with honest practices. If the use is not strictly necessary in the relevant context, again, it may not be in accordance with honest practices. And similarly to the US, if the use implies some sort of commercial affiliation, again, this would not likely to be considered in accordance with honest practices in industrial and commercial matters.
Interesting. So different but similar in a way.
Yeah, exactly.
Mm-hmm. If a navigation system displays, let's say, another company's logo incorrectly, you were mentioning the possibility of errors. Let's say it shows the wrong brand at their location. Who is liable in this case? Is it the navigation provider? I don't know, Google Maps, Yelp, or the car maker? Let's see, a BMW integrating the system. Who is to blame here?
Okay. So if we think about a situation where, I mean, this is a really interesting question. If you think about the situation where we have a third-party provider or a navigation system, say Google Map or Garmin or TomTom, then they are the source of the incorrect data. In the example that you've just provided, they would be typically the primary liable party. This is particularly where it is the platform that they provide that creates, maintains, and sometimes commercializes the POI data. There is no oversight by the car maker, and the provider, right, whichever provider it may be of the platform, they are likely to attract primary liability. Now, sometimes they actually, as part of their terms of service, they will try to introduce a cap to any liability in this context. These, of course, especially in the European context, don't always bite, because they cannot protect you, for example, against claims of typically of negligence or misrepresentation, the tort of misrepresentation. And this is especially so if we're talking about the tort of negligence, for example, where you have persistent errors. I mean, an error once in a blue moon is not negligence. It can happen. It's a technical glitch. But if you have a repeating pattern, the platform provider does not do anything or does not do enough in order to address this problematic pattern, you may be able to establish negligence, and together with negligence, you may have a liability in this context. Now, car makers may also attract many secondary liability, particularly in contexts, for example, where they co-brand, right? The interface in such a way that suggests that they endorse the content, right? So that can be the case. If they do maintain some kind of an oversight over the output of the third party that provides the navigation system, if, for example, they distribute a third-party system where they know or they ought to know that it contains a flaw, but they do nothing to address it, they just put it out there and say, it's not my problem. When you put it out there, then you may attract secondary liability because you have facilitated, in a way, an infringement by the third party. So it very much depends, but I would say that as a general rule of thumb, primary liability, the platform provider, the system provider, secondary liability is we have the car makers.
Yeah. I was thinking you were giving a very lawyer answer of it depends, but
Yes.
it's like the reality. It really depends on the specific situations. Indeed. Thanks a lot for making it so clear. I can really see all the years that you've been giving lectures and how structured with examples and everything you share the information.
So it worked in the end. That's very good.
It did. It really did. I'm very happy you said yes. And you came here today. So let's move to the next point I wanted to raise, which is, could the way brands are prioritized in the interface raise legal or competition concerns?
I find this to be one of the more interesting issues in the present context. So, I mean, the short answer will not be lawyery and depend. It would be yes. The prioritization of brand in a car navigation system in the interface. So, for example, displaying, let's perhaps explain what prioritization means. So, for example, displaying a certain service provider more prominently than others, that can raise both legal and competition concerns, especially in relation to what we call in Europe unfair commercial practices, general consumer protection issues, and as you said, competition, so competition laws. To what extent each of those issues is actually relevant, it really depends both on the prioritization, the nature of the prioritization, and the type of jurisdiction that we deal with. So, for example, misleading commercial practices, so these are consumer protection laws essentially. So where you have a prioritization mechanism in a way which is not transparent to the user, this may be considered misleading under consumer protection laws. For example, where you have certain brands that are giving preference due to paid placement, and that is not made clear to the user. The interface appears natural, but in fact it's commercially curated. So the user may think that number one appears because it's most relevant to what she or he needs, but in fact number one is number one because number one paid in order to be at number one. Then you may have an issue. And these are situations where users are actually steered towards those options that do not necessarily, as we said, reflect or express truly traits like proximity or quality or real issues that are relevant for user preferences, but are really about party who paid most. I think that competition is particularly relevant where you have a navigation system that systematically favor certain brand, where those brands are in one way or another are commercially tied either to the platform or to the car maker, right? Mm-hmm. So this may give rise to bundling and tying and so on. So when you have a system, for example, that holds a dominant position, when you have competitors that are excluded, and if not totally excluded, are disadvantaged in the way that the information is being displayed, right? And this kind of preferential placement is shown to distort consumer choice. Under such circumstances, competition law may kick in. So if you think about, let's say, a particular car brand, right, mm-hmm. that gives a preferential placement to its own network of garages, excluding independent providers, that may give a rise under certain circumstances to such a competition law issues.
No, it's interesting because a couple of weeks ago, I went to Spain to visit my mom, and I took a rental car, and I was driving. It was not even 2 minutes driving, and it was already suggesting to make a break, and the restaurant I needed to go. And I got upset, I have to say, because first, obviously, I didn't need a break after 2 minutes driving, and I know there are more places around. So I was always wondering, is it an error or is it that someone paid and that's why it's prioritized? So
I mean, you're a sophisticated consumer, Claudia. Perhaps someone who is less so, they would think, okay, that's the only option around, or that's the best option around, and they would go with it. And then that's exactly what we mentioned in relation to distorting consumer choice. Yeah.
Yeah. And in this sense, you were mentioning, or we were discussing these situations where the brand owners want to have this visibility, they even are willing to pay. But there might be situations where there are some issues they don't want to be seen. How can brand owners protect themselves when partnering with automakers?
Of course, when there is use without any permission given, to the extent that in the relevant jurisdiction that use rises to the level of infringement, then they may enforce their trademark rights. But quite often, what you do want as a brand owner is to seek a license, because when you have a license, you have the ability to regulate the type of use that is made of your mark. So a license you may insist on such an agreement would specify or list the permitted forms of use, right? So static display, promotional placement, and so on. For example, it may include prohibitions on logo modifications, right? Your brand modifications. So you would say, look, you can use, but exactly what I allow you to use, and no modification, additions, deletions, and so on. So prohibition on modifications, on any stylization, or any use in misleading context. You may wish to actually put some restrictions in terms of territoriality. So maybe you're happy with a certain type of use in certain territories, but when this car is being sold in other countries, then maybe you want to have, or you wish to have, for various strategic reasons, a different type or level of regulation. And generally speaking, before an infotainment system is launched, and that infotainment system has the ability to display your mark, you would also like to have some kind system of some kind of prior approval where you can actually, you would like to hook up into the system, see how your brand appears, and then decide whether you're happy with that, and that's essentially as some kind of a prior approval system. Generally speaking, there is also an issue of quality control. Now, trademarks in quite a number of jurisdictions, trademark law require that right holders exercise control over the quality of the goods or services provided under that mark. Otherwise, if not, they don't do that, they may lose the mark in the end of the day, right? So because if the mark stops signifying a particular commercial source, because people can use the mark in various contexts without you as the proprietor being able to control the type of use, it doesn't mean much after a certain period of time. So there need to be some kind of a quality control, and therefore you may wish to have the right, you as the brand owner, to audit the use periodically, right? You may wish to insert some reasonable obligations to maintain accuracy, technical accuracies, for example, correct location data, of course, giving some room to some reasonable technical glitches and so on, and maybe also have a certain takedown mechanism that enables you, when you see something which is a no-no, you can jump in and say, first of all, before we continue to discuss, take it down now because it's generated damage to my brand. And lastly, the question of sponsorship. When you are involved, where you are a brand owner that is paying for prioritization, you would like to ensure that the brands or the prioritized list is displayed in such a way that sponsored content is clearly separated from general content. So you have compliance with consumer protection laws and so on. And generally speaking, avoid any misleading impression about endorsement and so on. This goes beyond what you contractually agreed with the prioritizing platform.
Considering all what we have discussed, which has been a lot, what best practices would you recommend to companies to avoid trademark conflicts in this space?
Okay, so I think, so in relation to companies, as much as possible, they should try and secure clear trademark licenses for brand use in navigation interfaces. They need to, as far as possible, ensure accurate and non-misleading brand display and avoid the implication of endorsement without authorization. I think interfaces, and I mentioned that a number of times in the different contexts of our discussion today, interfaces should make sure to distinguish between sponsored and organic lists or contents and provide, especially in Europe, a transparent tracking criteria so the user knows exactly what kind of criteria is being taken into consideration when ranking is actually decided. When collaborating with brand owners on quality control and error correction, data governance, and so on, this also makes sense. So both companies and brand owners collaborating together and trying to establish the relationship through a license on those issues can give you some peace of mind. And I think one last point is, in light of our discussion, you as a company must bear in mind that the trademark laws vary quite significantly between various jurisdictions, and you need to tailor your practices to local trademark laws, especially in relation to exceptions. And again, we're mentioning the same name, nominative fair use. So when nominative fair use is limited, you may have to have pretty different practices than you would have in places like the United States or even in Europe when we have, as I said, Article 14. And lastly, keep an eye on the evolving standards in advertising and digital platform regulation. Again, the EU is much more active in that respect, just to make sure that you are on the right side of those regulations.
All excellent tips. I think I could not have asked for more. We are reaching the end of this episode. And as always, I like to ask also you, as a guest, can you share a lesson learned from your private or professional life?
I guess this is a topic that can fill a podcast in its.
The older we get, the more less.
No, actually, the older we get, the more complicated the answers. I'm not sure it's longer. It just what kind of factors that take into account. But I think that when it comes to my professional life, it doesn't matter how much you delve into a topic, you are never in a position where you can actually address, answer, or respond to every question in that particular context. And I think that when I was younger, so when I started my academic career, there was more stress to, I don't know if proving others, but first of all to yourself that you're worthy of your role. So you would try to answer any question that you were asked, whether or not you were 100% sure. So you would unpack it further. I think the older you get and the more comfortable you are with your position, you realize that there is absolutely, under certain circumstances, and hopefully a very limited set of circumstances, but it may happen when, for example, a student asks you a question in class and you say, you know what, this is a fantastic question. I've never, ever put any thought to it, and I need to give it some further thought. So I'll come back to you next week, and it's absolutely fine. And that's definitely one of the things that have changed in my case throughout the years.
I recall when we were doing training on panel discussions, and we were trained also to answer very difficult questions that there's no way we could have known. And I recall at that time being comfortable saying, I don't know. I'm happy to collect the question, and if you give me your business card, then give you the answer next week. And I recall at that time they told me that was a good answer, because one of the worst situations is when you are going in public saying things which are not true just to feed your ego. But I, as a young professional, I was exactly doing that. I felt that I had to answer every single thing that they was thrown to me.
So it's nice and refreshing to see that we kind of share the same experience, and that we have evolved professionally in a similar fashion. So that's brilliant.
It is. So Noam, thank you so much for joining the episode, and thanks also to the audience for joining us. And please comment and click like if you like it, which I'm sure you did, because I know Noam and I've been enjoying so much this talk, and I'm sure you have too. And that's it for the day. Thank you.
Thank you, everyone. Bye-bye.